Hi, everybody, and welcome to the August 2019 version of the Third Fridays podcast. My name is Christian Cisan, and today I'm welcoming again my partner, Declan Gourley. Welcome to the show.
Thanks for having me back.
Yeah, you say having you back. I guess it's a real contest because everyone versus Greg is an issue for him. He loves being on the show, and I also love not having him on the show. So it's extra special that you're on today. Today we're going to talk about...
Criteria number one, I'm not Greg Lowe.
Right. You're ahead of the curve. The mental stress injuries that are a part of our world in New York workers' compensation, we're going to talk about today. And actually, it's as per a request from a fan or a listener or a buddy, however you want to call this person. So
Fan makes you sound cool.
That's true. I should just say fan, like as if I don't know this person and we haven't been to many conferences together. But you know who you are if you're listening or watching this. This is for you. So mental injuries are kind of like the perfect topic for this podcast, actually. And I kind of wish I thought of this on my own because it implements Defend from Day One to a T, like rather perfectly, right? So let's talk about first the idea of a mental injury arising from work, right? Like, because we don't want to demonize or really state that there's no possible chance that someone can get stress from work, right? We can get stress from work. The only problem is that stress is such a avalanche coming from all different directions, right? Like we get stress from things outside of work that contributes to our overall condition, right? Would you say that's fair?
Definitely.
Right. So like, if I still don't know where to put the Tupperware in my house, my wife is stressed, and then that makes me stressed. But that doesn't mean that the 8 appeals that my team has to file this month also doesn't give me stress, right?
That was a very specific example.
Right. It's like I say this because I wonder if my wife actually listens to the podcast or views it on our website, and I'm going to create this conversation with her in a couple of weeks and ask her how stressed that whole situation makes her. And if she reacts more aggressively than she would, then I think that I can trust that she listens and watches the podcast, right? It's a little test.
Creating stress for her. Tests to see if she's listening to your podcast.
Test for more stress. You're right, Declan. I have a lot to learn. This 2-month-old marriage is still up and running. So anyway, right? Like we're saying, we're not going to demonize it, but the idea that stress can come from work is very difficult to really accept because of those factors, right? So the standard in most cases is that the person would have to feel stress that is greater than that of a similarly situated employee, right?
Right.
And that goes back to, that almost goes back 20 years. So what does that mean in layman's terms, similarly situated employee and greater than that experienced?
Basically, if it's something that you're in your work environment that everyone else faces and would not be as stressed as you are, and it's a normal thing almost, then it doesn't meet the standard. And I think of oftentimes when you think about these, it's usually employer decisions, whether someone didn't get promoted, but in this day and age, in the age of everyone being offended by everything, I think that these claims are going to become more common.
Okay, no, that's a good point, and actually we'll touch on that going forward. But back to the appeals filed by a team, right? We're in a similarly situated position, right? And you might have maybe even more appeals to file on your team this month. But if I have stress from that, I'm not experiencing a greater stress than you are, right? So that would be an example where if I filed, then I wouldn't meet the standard for causally related and compensable stress or a psychological condition as a result of that direct experience, right?
Right.
Okay.
The idea being you have to have a baseline. And if you're just a very stressed out individual, then something very, very minuscule could basically set you off, and that shouldn't be the standard.
Right. And we want to make an exception or maybe a different standard, not make a different, but talk about a different standard as it relates to first responders. And that's one of the biggest reasons I had you on today, because you have a lot of experience with those claims. So talk about like what that means for first responders.
So in April 2017, the statute actually, the legislator enacted new legislation that removed that standard of care. So no longer have to prove that your stress was greater than a similarly situated worker. And this is most common with, or specifically regarding EMTs, police officers, and firefighters. The defense previously was these stressful situations are supposed to be your job. That's what you were signed up for. But the legislator has removed that.
And it was a tough blow for employers and carriers because essentially we're now acting under the premise that even though it was an assumption of the risk when you took this job, right? Like it's very hard to be a first responder and not experience stress. And it to me at least, it made sense that if you rose to the level of something greater than that of your similarly situated employee or coworker, then that made sense to be a compensable injury. But just to show that stress existed, it really just doesn't sit well with me, right? Like you are signing up for that, and that's why these individuals are so valued in our society, because they are taking on that role. And I don't want to again take away from the fact that they do experience the stress, but to it's kind of like taking it on one end and burning it on the other. Any position or opinion on that?
I can see situations where it can be abused, but I also see situations where just because you're a police officer and you might have to use your service weapon, you didn't necessarily sign up to shoot people. So I can see how it can go one way or the other.
Okay. No, that's fair. But that's basically where we're at right now, right? We want to differentiate the type of employee that we're talking about and the standard that it is to defend against those types of claims. So let's talk about the more general employee, the non-first responder, right? What I'm thinking is an incident happens, right, that causes a person psychological distress. And I think that if an employer approaches the situation as if it is legitimate, it can actually help them whether it's legitimate or not, right? So you're actually taking care to find out what caused this, what can we do better, and interviewing the employee before the employee becomes a claimant, right? And that's what I love to stress with DFD1 is like, if you treat the employee like an employee, he may not be a claimant.
Right.
Right.
And these are very fact sensitive, so you want to get as much facts immediately as possible.
Sure. So, making the right steps with the employee to ensure that if it is legitimate, this person is going to be taken care of. So being quick to fix and remedy the situation and gain all the facts you need, because if it turns out to be to be illegitimate, then essentially those facts are going to help you defend the claim later, right? What exactly caused the stress? What role did the employee play in that situation? And can this be corroborated by coworkers, supervisors? Because these are the things that you're going to have to present at trial, right? Like if someone experienced stress as a normal non-first responder, then your idea or your goal is to show that other similarly situated coworkers also experience this stress. So corroboration and verification of that incident from the get-go is not only important, but it's almost mandatory.
Right. And I do think it helps to show that you immediately move to mitigate whatever that stress was, if it's possible.
Right.
If you have a workplace bully, for instance, or
right.
someone calling someone names, the second someone tells you about it, you move them away from that person or you reprimand that other person. It shows that this was an ongoing thing. Right. But if you just leave them there and you let them be bullied for the next 6 months to a year, then I think that also does not help your employee morale, but it also does not help your workers' comp claim either.
Sure. So that's really the best way to defeat that type of claim, or at least put up a viable defense, because we know that even though that there are pre-existing conditions that can lead to overall stress, how likely is it that, one, the person's going to seek treatment for non-work-related stress, and two, how likely is it that that's going to be the sole cause of the stress? Because one of the things that the cases talk about is that you can have a pre-existing condition, but if the claimant can show that there's an exacerbation of that with a specific incident, and you don't really defend the nature of that incident, then the claimant could have a compensable exacerbation claim, right? So an IME and a prior record, and those are the types of things that are more helpful for the physical, orthopedic, neurological injuries, because we can show the comparison of diagnostic testing to each other. But would you agree that you can't really defend the claim on a medical basis, even if there is pre-existing?
It's difficult.
Conditions?
I can say that we've had some experience with someone that had a claim for established for major depression, or attempting to establish for major depression, arguing that because of the claim currently that they were having suicidal ideation. And I hate to say the word thankfully in the situation, but thankfully we were able to get medical records that show that within a month of the work accident, they were already experiencing suicidal ideation. So that right there is a very significant factor to show, hey, how can you say it's related to this? And this is a consequential. This isn't purely a mental health claim, but this is a consequential claim for major depression. They're saying that because of my work injury, now I'm having suicidal thoughts, and the records show that was existing prior to our work injury. So how can you say it's truly consequential?
Right. I think that's a great point because it kind of actually supports the idea that there are different ways to combat this problem. I think with the IME and the prior conditions, it's more of a how much stuff can we throw against the wall,
right,
to really show that there's just no medical probability that this is causally related, right? I just had a case where we were able to get consequential psych disallowed because there were prior conditions reported to the IME but not to the treating psychologist, and they were so severe, right, that it just made him look less credible in providing the PFME, right? We're talking about like hospitalizations for prior psychological conditions, accusations of criminal conduct by family members that caused, these are serious things.
A little bit of stress there.
Yeah, it's a little bit more stressful than what I had initially opened the show with, not knowing where to put the Tupperware, right?
Maybe.
No, yeah, we'll see. We'll see who's listening to this. I might get a little in trouble for that. But okay, so now we know the standard, and now we know how we would try to push for a disallowance or a denial of the claim. But let's talk about either the situation where a client accepts causally related stress, or you litigate it and it becomes established. So now it's very unlikely that you're going to have just a stress claim, but you might. But let's talk about the claim where you have a stress experience and also orthopedic injuries involved, right? How do we defend LWEC in the process where you have two competing stresses that don't necessarily go together for a severity ranking?
It can certainly be difficult. It's more important than anything else is getting their medical records to see what was going on. But with respect to both orthopedic and psych, you're going to need two different IMEs. There's permanency for, obviously, orthopedic injuries. If it pertains to back injury, you have the permanent impairment guidelines pertaining to the back, but you also have a classification related to psychiatric conditions. So I would say that usually they stack, but our argument is that just because you have the equivalent of a 50% orthopedic disability and you have a 25% psychiatric disability, doesn't necessarily mean you have a 75% total overall loss of wagering capacity.
Right. It actually could be more. It could be less.
Right.
It's really there's no science to how we kind of deal it with orthopedic and neurological, right? There's no science to how these different injuries or conditions come together for an overall medical impairment. You have to just get the right IMEs that find permanent disability, and then push for a medical finding before the vocational is attached. So, going into, I guess, the elementary discussion of LWEC, right? It's a combination of medical permanency and vocational factors that are associated with the claimant's ability to reach gainful employment, right? So,
and they should certainly be asking them about their activities of daily living, because there's nothing more frustrating than if they don't ask them basic questions. I mean, if someone says, I'm totally disabled, I can't do anything, but then that they leave their house, they belong to social clubs, they go shopping 4 times a week, they plan family events, like they're doing all these things. It's like, well, how disabled are you from your psychiatric impairment if you're living this otherwise normal lifestyle?
Right. And it's a huge point, right, to cross-examine, because once you can have medical permanency found, cross-examining the claimant on vocational factors actually might allow you to dispute medical permanency and bring an overall severity ranking down. But essentially, from the medical side of it, right, I think you want to, in an ideal situation, make it more clear, right? So if either the physical injuries or the mental injuries have reached MMI with no disability, it's a lot easier to focus and value a claim when one condition has allegedly or arguably resolved, right? So I think that's really the best thing I can really offer when these types of competing conditions come into play, is that if you can get one of them to resolve with no further causally related disability, again, easier said than done, but if that is your option, you can value the claim as if we just have a remaining orthopedic disability.
Right, because in theory, I usually these consequential claims is I have a back problem and a back pain and I can't work and therefore I'm depressed. Well, if we've now gotten your back pain a little bit better where you can work, well then in theory your depression should start to subside. Or if it's I'm depressed because I'm in constant pain, well if we have you your back pain is starting to get better, well in theory your depression starts to subside at that point too, because if you're not in pain all the time, then presumably your depression should begin to wean as your physical disabilities begin to get better. Right.
So I wanted to discuss two recent appellate division cases and to show how these theories are being put into play.
Test?
No, it's not going to be a test. There's not going to be any questions that discuss exactly how you're doing, but I think it's going to actually make sense based on what we've talked about, right? So the first one is Kraus versus Wegmans Food Markets. It's a December 2017 case where the board ruled that the claimant had a causal-related accidental psychiatric injury, and the employer appealed because, of course, right? In this decision, right, it really talked about how there was a prior condition, right? That he sought treatment for something before this incident happened. And they really went into the discussion of just because that happened doesn't mean that it can't be exacerbated, right? And
so you're saying prior psych treatment?
Correct.
Okay.
Correct. And here is where a defend from day one philosophy can actually maybe not necessarily change the overall final determination of the case, but may actually save you some, considerable amount of time and expense in having to, not go so far with legal, right? I mean, there are multiple witnesses from the employer who testified that the relationship between the claimant and other coworkers became adversarial, right? Claimant's supervisor testified that claimant felt threatened by a coworker within the department all the time, and that an employee was barred from the building due to his abuse of the claimant. So yes, we are remedying this situation, but they were also admitting that this is something that's happening, right? Claimant's supervisor also testified regarding an incident involving a particular driver who was upset about the status of benefits and claimant feeling very threatened by this particular driver, because the claimant is an administrator of the employer's no-fault policy, right? So then he is making the determination as to what drivers.
I was wondering what this job role was, that he had so many threats from
Maybe
so many
I should have
different
given you a
people.
little bit more background. But
that makes sense. So you're ruling against your coworkers and their long-term disability or their policy claims,
right.
And then they're going to be upset with you and maybe even threaten you because of that.
Right.
That makes a little bit of sense.
Right. And then from the medical portion, right, you have claimant's doctors who are finding that there is causally related PTSD, right? He had a fear that he was going to be attacked and beaten and killed by his coworkers, which is more damaging emotionally and to hear really than the medical portion of it, but it nonetheless still exists. The problem is that the IME from the employer said that the current disability was not causally related to the harassment, and the symptoms were related to his prior condition, but he agreed that claimant's stressful interactions may have made his illness worse, right? So here we have a situation where they may have done a great job of defending from day one in finding out this testimony, and they got the IME that talked about prior